John Roberts was born on January 27, 1955 in Buffalo, New York. He grew up a captain of the football team, a wrestler, and a part of the student council. John Roberts graduated from La Lumiere High School in 1973 and after that attended Harvard University in 1976, where he got his bachelor's degree and graduated with summa cum laude. After he attended Harvard Law School in 1979 and graduated with magna cum laude. In 1980 to 1981, Roberts served as a law clerk. From 1981 to 1982, he then served in the Reagan administration as Special Assistant to U.S. Attorney General William French Smith. Then from 1982 to 1986, he served as an Associate Counsel to President Ronald Reagan. On July 19, 2005, Roberts was appointed by George W. Bush to fill the vacancy on the U.S. Supreme Court of Associate Justice Sandra Day O'Connor. Roberts was then confirmed by the U.S. Senate by a vote of 78 to 22 on September 29, 2005. John Roberts ruled on the case Citizens United versus Federal Election Commission. This case argued that the First Amendment protects rights of business, nonprofit organizations, and other groups to make unlimited expenditures. He also ruled on the case Morris versus Frederick. This case argued that educators have a right to regulate student speech expressed at or near school-sponsored events. Some fun facts on John Roberts are that he is married to Jane Roberts. He is the father of 2 adopted children, Josephine and Jack Roberts, and he is a part of the Roman Catholic religion. Supreme Court case Engel versus Vitale. The petitioner in this case was Stephen I. Engel, and the respondent was William J. Vitale, Jr. The case was first argued on April 3, 1962, and was finally decided on June 25, 1962. The case originated in Herrick School District in Long Island, New York. The case began because a New York state law required public schools to open each day with the Pledge of Allegiance and a non-denominational prayer in which the students recognized their dependence upon God. The law allowed students to absent themselves from this activity if they found it objectionable. A parent then sued on behalf of his child, arguing that the law violated the Establishment Clause of the First Amendment as made applicable to the states through the Due Process Clause of the 14th Amendment. The main issue was whether or not school-sponsored prayer in public schools violated the Establishment Clause. This case was sent to the Supreme Court because some argued that the law did violate the Establishment Clause of the First Amendment and because it was applicable through the Due Process Clause. The case was then ruled yes 6-1. The majority held that school-sponsored prayer violates the Establishment Clause of the First Amendment. The majority stated that the provision allowing students to absent themselves from this activity did not make the law constitutional because the purpose of the First Amendment was to prevent government interferences with religion. This case had an impact on American society as it was one of the first in a series of cases in which a variety of religious activities sponsored by the government were found to violate the Establishment Clause. This was the first case which effectively prohibited the government from sponsoring or endorsing any type of official prayer in schools.